What's up, ladies and gentlemen, and welcome back for round 2 of Richard Weed or Arizona Unfiltered's trial that took place the other day. If you didn't catch part 1 will be linked in the description of this video along with part 3 when it comes out. It'll be there. But you're watching part 2 right now. Part 1 was just kind of a warm-up. You should watch that if you haven't seen it. Gives more context to what's going on. But part 2 is where we get into the actual railroad of the trial. I'm going to stop it and point out some obvious things. I'm not going to point out everything. You can help me with that in the comments if you want. Point out all the mistakes that were made either on Richard's side or on the prosecution side. Really doesn't matter. Let's hear your opinion on it. I listened to a lot of court proceedings, and I have listened to a lot of them over the years. And I'm telling you right now, you've never heard anything like this. This is a blatant disregard for the 14th Amendment and Richard's right to represent himself fairly, to be quite frank with you. You need to pay attention to everything that happens because this is so blatant anymore that they're not even trying to hide it. Be sure to subscribe to Richard's channel, or Arizona Unfiltered. A link to his channel will be in the pinned comment and the description of this video. Enjoy!
All right, any cross-examination? Any questions for this witness?
I do. Let me. Okay. Okay. We've already gone through who you are and where you work for. That's already on the record, so we can go ahead and skip all that. Again, just like I did in our interviews, I have to ask you again, have you consumed any alcohol or taken any medication in the last 24 hours that would affect your memory ability to answer these questions?
No.
Okay. Have you had adequate sleep and rest prior to this interview, or this trial today?
Yes.
Okay, all right. And you did review your body-worn camera before trial today?
Yes.
Okay, all right. Are you confident in your memory and understanding of the stop?
Yes.
All right. Are you a certified mechanic?
No.
Okay. And so then what was the exact law or vehicle code you believe that I did violate?
ARS 28955A.
Okay, and that states a motor vehicle shall be equipped at all times with a muffler that is in good working order, consistent operation to prevent excessive or unusual noise. Is that correct?
Correct.
Okay. All right, then. Do you know what the elements of that statute are?
I'm going to have to ask you to rephrase your question because you just read it off.
Objection and relevance.
There's.
Wait, one moment. Once there's an objection, you have to stop. So
Your Honor, this is a question pertaining to the basis for the stop. This is going back to the same thing that the defendant argued in his opening statement, which was that there was no legitimate basis for the stop. Again, that's already been ruled on by the court whenever the defendant filed motions.
So, Mr. Weed, let me help you help yourself. We're not going to talk about the legality of the stop. That is not what's issued here. What is at issue is whether you are in violation of misconduct involving weapons and failing to accurately answer the officer. It's 13-3102A1B. That's the only issue in this case. So the objection is sustained. Next question.
What you're hearing are major procedural errors, particularly in the judge's handling of Weed's ability to respond to the objection and ask important questions related to the legality of the stop. This collaboration and collusion between the judge and prosecutor to limit Weed's ability to present a defense and challenge the basis of the charge absolutely undermines the fairness of the trial and direct violation of the 14th Amendment. The fruit of the poison tree doctrine provides a legal basis for Weed to argue that if the stop was illegal, the subsequent charge of misconduct involving weapons needs to be dismissed. Magistrate Alicia Lawler and Prosecutor Austin Brooks are either incompetent or outright corrupt. I'll let you be the judge.
Okay, so nothing about the muffler or the initial stop. Okay. That is being barred from the court.
So, Mr. Weed, I'm going to ask that you refrain from the commentary, otherwise we're going to move on. This is your time for cross-examination. I've been told you what's at issue in this trial. Do you have any other questions, sir?
Yes. Can you recite the language of ARS 13-3102 from memory?
No.
Is it okay if we go ahead and put the body cam up on the screen?
Sure.
Okay.
But can I ask you what the question's going to be then?
Well, it relates to the question I just asked him. Can you recite the language of ARS 13-3102? If need be beforehand, I can explain to you why I would show the video.
I'd like to know a proffer of truth, an offer of proof, yes.
Okay. When I was arrested, I challenged him on the questions he asked me, and he stated to me, no, sir, that is not how the statute is written, as if he knew how it was written while he was enforcing it.
I'm going to overrule and ask that you move on. I don't need to hear that. We all know what the statute says. That's what you've been cited with. There's no question about what you were cited with, so move on.
Okay, this part's very important that I point out. With this line of questioning, Richard wanted to show that the officer didn't know the law's detail, which would make the officer look less credible and support Richard's argument that saying, I don't answer questions is not a crime under the law. The law only punishes giving a false answer about carrying a concealed weapon, not staying silent, which Richard has a constitutional right to do. But Judge Lawler stopped Richard's question saying, I don't need to hear that. We all know what the statute says, even though the prosecutor didn't object. This wasn't just unfair, it broke the rules of a fair trial and Arizona court procedure, robbing Richard of his chance to defend himself properly. The 14th Amendment guarantees everyone a fair trial, meaning you get a real shot to tell your side, challenge the other side's witness, and show why you're innocent. This is called due process. When Judge Lawler stopped Richard from questioning Officer Duran about his understanding of ARS 13-3102, she violated due process, specifically by blocking Richard's right to challenge witnesses. The Constitution says you can question or cross-examine the prosecution's witness to testify or to test their truthfulness or knowledge, and that's Davis v. Alaska. Richard's question about whether Officer Duran knew the law were meant to show the officer might have been wrong or careless in arresting him. For example, if the officer didn't understand that ARS 13-3102 only punishes lying, not silence, it could prove he misapplied the law, making his testimony less believable. By cutting off these questions, Lawler took away Richard's right to challenge the officer's credibility, which is a core part of a fair trial under the 14th Amendment. Crane v. Kentucky. Judge Lawler also violated the 14th Amendment by stopping a valid defense. Richard's defense was that his silence or his response, I don't answer questions, didn't break ARS 13-3102 because the law doesn't force you to speak. It has no obligatory language. It only punishes giving a wrong answer. He has a Fifth Amendment right to stay silent. Miranda v. Arizona. And questioning the officer's knowledge was meant to show the arrest was based on a misunderstanding of the law. Lawler's statement, we all know what the statute says, assumed the law was clear and shut down Richard's chance to prove the officer got it wrong. This violated his right to present his side of the story, another key part of due process. Chambers v. Mississippi. Judge Lawler was in severe error when she started acting like the prosecutor instead of remaining the judge. Lawler stepped in to block Richard's questions without the prosecutor objecting. That's a big deal. Judges are supposed to be neutral, not take sides. By jumping in and saying the questions were not needed, she acted like a second prosecutor, helping the state's case and hurting Richard. This unfairness, called judicial bias, breaks the 14th Amendment's rule that trials must be impartial, and that's Tummy versus Ohio. or Toomey, Tumey, versus Ohio. It's like the referee in a game picked a side instead of calling it fair. And that's not all. Lawler's actions broke several Arizona court rules by ignoring cross-examination rights. Arizona Rules of Criminal Procedure allows defendants to cross-examine witnesses to test their testimony. Richard's questions about the officer's understanding of ARS 133102 was relevant because they could show that the officer didn't know the law he was enforcing, weakening his credibility and the arrest's validity. Lawler's overruled these questions without legal reason, saying, "I don't need to hear that," which violates the rules. She was also in serious error by overruling something that wasn't objected to. In court, a judge shouldn't block questions unless the other side objects and gives a valid reason. The audio here shows the prosecutor didn't object to Richard's questions about the statute, yet Lawler stepped in anyway. This is a procedural error, as judges can't just shut down questions on their own without a proper objection or a clear rule violation. Lawler's interference was unfair and against court procedure. She also seriously erred in misjudging the relevance of Richard's question. Lawler claimed that officers' knowledge of the statute wasn't relevant because we all know what the statute says. But relevance in court means anything that could affect the case's outcome. The officer's understanding was relevant. If he didn't know ARS 133102 only punishes false answers, his decision to arrest Richard for silence was wrong, supporting Richard's defense. By wrongly calling this irrelevant, Lawler broke evidence rules and denied Richard a fair trial, in complete violation of the 14th Amendment. Here's why this is important for regular folk like you and me. Let's imagine that you're in court trying to prove you didn't break the law, and you want to ask the cop who arrested you if they even know what the law says. You're trying to show they made a mistake, but the judge stops you, says that it doesn't matter, and doesn't let the other side complain first. That's not fair. It's like being told you can't defend yourself, which is bullshit.
Is it true that subsection A1 specifically prohibits knowingly providing false fictitious informations?
Objection, relevance.
That's A1 of what?
3102 A1.
He's asking a police officer about what a statute says. I don't see how that's relevant to what a defendant did or did not commit this failure to answer.
So, Mr. Reed, the objection is sustained. I mean, I'm trying to help you to focus. It's not whether this officer can recite the statute from memory. You've been sided with the statute. You're presumed innocent. The state has to prove every element of that crime. So you can continue with your cross-examination. Whether this officer can recite that from memory doesn't matter.
All right. If it turns out you arrested for someone for something that is not actually a crime, would you consider that a violation of their rights?
Again, objection, relevance.
Sustained. Next question. The only issue, Mr. Weed, is whether you're in violation of ARS Section 13-3102A1B. Any other questions?
Okay, yeah, I had a lot in here. Now I have to go through and kind of narrow down.
Yes, because only relevant questions are allowed.
Is it true that the Fifth Amendment would protect an individual from being compelled to answer during a police stop?
Again, objection. This is, if the defendant wants to make legal arguments regarding the Fifth Amendment, he can do that in his closing argument.
Sustained. Hold on.
Did you interpret my refusal to speak as deceptive or criminal?
Did I interpret it?
Yes.
Objection, speculation.
Sustained.
Did you record any statement from me that was false or fictitious?
Are you talking about on Axon body-worn camera?
Yeah, I am.
Any statement from you that was false or fictitious?
Yes.
Yes.
What was that I said that was false or fictitious?
Your failure to answer the question that was asked for you on the initial stop.
So that was a false statement?
It wasn't a statement at all. It was not nor false nor fictitious. It was the truth. It was nothing.
Okay.
You know, I'm sitting here listening to this, and he says, yes, that you made a false or fictitious statement on my body camera. And then in the span of 10 seconds, he says, you didn't make a false or fictitious or even make a statement at all. It was nothing. Anybody else notice that weird shit? And they just get away with that. Did you use the like button?
Did you say in your report that you identified yourself with your name and badge number when you approached the truck?
I did not identify myself by my badge number when I approached your vehicle, no. I did identify myself by my last name.
Okay. And did you discuss the presence of the axe with any other officer before the Terry search of my truck?
No.
When did you first see the axe? Before? Was it before Maldonado brought it to you while you were sitting in your vehicle? Or was it after?
When I first observed it?
Yes.
When Officer Maldonado brought it to me.
Did you tell Officer Maldonado to stay and watch the passenger as you walked around the vehicle?
I do not recall.
Okay. I would like to play the dash cam or the body cam evidence of Officer Duran for the last 1, 2, 3 questions I gave him.
And to what point?
The officer just lied on the stand.
As to what question?
Actually 4, I guess. Did you identify yourself? Did you discuss the presence of the axe before the Terry search of my truck? When did you first see the axe, before or after Maldonado brought it to you? And did you tell Officer Maldonado to stay and watch the, well, actually, you know what, that one he didn't recall, so it was the 3.
So, Mr. Weed, again, I'm going to deny that request and again focus you on what I am interested in, what the state has to prove, okay? The only issue in this case is whether the state can prove beyond a reasonable doubt the elements of this crime. That is the only thing that is relevant. 3102, A1B, only thing that's relevant.
So perjury has no effect on this?
I can only repeat my words to you. Move on, sir.
I'm not going to go into a long rant about this because I think most of us understand what we just heard, but not allowing Richard to call out perjury when it's happening and not allowing him to attack the officer's credibility and just ignoring it is crazy.
Did the prosecutor tell you that you should have removed the passenger instead of the weapons from the vehicle?
Objection. How is it relevant what the prosecutor talked? It's also hearsay.
No, it's not. You told me in that hallway in front of people out in the open. You said that
Mr. Weed, stop.
they ought to.
Mr. Weed, stop. It's not relevant. It is not relevant.
Okay.
So the objection is sustained.
No further questions.
Any redirect by the state?
Extremely brief one, Your Honor. The defendant asked you, Officer Duran, whether the defendant made any false or, whether he made any false or fictitious statements while interacting with you. Did he call you a lying ass?
He did.
Okay. Are you a lying ass?
No.
So would that be a false statement?
Objection.
Correct.
What's the objection?
He lied in court before this. He's lying in now.
It's not a legal objection. The objection's overruled. Anything further from the state?
Nothing further, Your Honor.
All right, you may step down, Officer Duran. State's next witness.
State Police Officer Maldonado, Your Honor.
Officer Maldonado, come on up and be sworn.
Oh. Okay, yeah. So will you hand that to him?
Yes.
Oh, hold on, let me mark it real quick. Grab that. What is this? Thank you. Now you step out, Officer Duran, you said I may recall it.
And Officer Duran is leaving the courtroom. I'm just making a record. All right, and Officer Maldonado, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Have a seat, sir, and you are a witness.
Thank you, Your Honor. Okay. Officer, just like Officer Duran, you're wearing a Mesa PD t-shirt today. You work for Mesa PD.
Yes, sir.
All right, could you state your full name for the record?
Yeah, Marcus Maldonado.
Officer Maldonado, were you working for Mesa PD back in December of this past year?
Yes, sir.
All right, did you complete a traffic stop involving the defendant, in this case, Richard Weed, that also had Officer Duran involved?
Yes, sir.
All right, what happened throughout the course of the stop?
Located a weapon inside of the vehicle, which I identified as an axe.
Let's backtrack. So, were you present whenever Officer Duran had the defendant step out of the vehicle?
Yes.
Okay. Was the defendant the only person in the vehicle?
No, sir.
All right. Was there a passenger in the vehicle?
Yes.
While you were conducting this traffic stop, how was your interaction with the passenger?
Very minimal. Passenger refused to answer questions and refused to talk to us.
Okay. Was he trying to interact with you by making fun of you as a police officer or making any sort of
Objection.
instigation with you?
Relevance?
One moment.
It's relevant to the basis for how the evidence came to light, Your Honor. So the instigation is what led to the safety exception coming into play for the defendant, or for the officer to remove the axe from the vehicle, which is what led to the handgun being discovered. So
Objection's overruled.
You see what he did there? It's called leading the witness.
okay. So in this case, was the passenger trying to instigate interaction with the police officers?
Yes.
Okay. Based on that instigation, had you observed the axe that was in the vehicle at that time?
Let's say it one more time.
Was there an axe in the
Yes.
back of the truck? Okay. Did you see the axe?
Yes,
Did you make a decision to remove that axe from the vehicle?
I did.
All right. What was the reason for you removing the axe from the vehicle?
I perceived it as a threat, easy, accessible by the passenger. Based on the escalation of the stop, I decided to remove the axe out of the situation.
All right, so the prosecution is attempting very weakly to make a Terry search argument right now on why the officer took the axe. And that's important that you understand how this doesn't apply to this situation, because in a Terry search situation, the officer has to believe that the men are armed and dangerous and pose a threat to the officers in combination with specific, articulable facts that would lead a reasonable officer to believe that they were armed and dangerous. And just seeing an axe in close proximity and some sort of loose explanation on escalation doesn't cut it.
All right, so right now I have exhibit number 1A paused at, I believe, 2 minutes and 18 seconds. Is that you in frame right now?
Yes, sir.
All right. Is that the passenger also in frame towards the center of the screen wearing an orange-billed camo Arizona Diamondbacks hat?
Yes.
All right. What does he have in his hands?
A cell phone?
Is he recording you?
Yes.
Okay. In frame as well, is there the wood handle of an axe to the left or the right-hand side, which would be the passenger's left-hand side of the vehicle?
That is correct.
Is that the same axe that you made the determination to remove from the vehicle?
Yes.
Officer Duran was wearing a body-worn camera, or you wearing a body-worn camera that evening as well?
Yes, I was.
Have you reviewed it before today?
Yes.
Does it appear to be a fair and accurate representation of your axe on body-worn camera?
Yes.
I'm showing Your Honor, at this time, I'd move to admit what's marked as State's Exhibit 1B.
Any objection?
No.
The State's Exhibit 1B is admitted.
I'm playing State's 1B at 0 seconds here. Okay, I paused it. I'm going to rewind it just a second and pause it again here. I paused it 24 seconds. I'm going to rewind it to about 22 seconds. All right, right here at 22 seconds. At this point, in your right hand, do you have that axe?
You can stand up, officer, if you like.
In your right hand, do you have the axe that you were removing from the vehicle?
Correct.
All right, in your left hand, what is that?
Holster handgun.
Okay, is that in the driver's side panel door?
Correct.
Okay. Was that within the defendant's immediate control if he was in the driver's seat?
That is correct.
Were you able to, did you take that into custody?
Yes.
Was it sent to evidence, brought to the evidence lab from Mesa PD?
Yes.
All right, was it brought to court today?
Yes, it was.
Okay. Who checked it out from Mesa PD?
Officer Duran.
Did Officer Duran give it to you?
Yes, he did.
Do you have that with you right now?
I do.
So in this box right here, is that the gun that's on the screen right now?
That is correct.
Okay. Is it unloaded at this point?
Yes.
Okay. Where is the ammunition?
In this brown bag.
So there are two different exhibits here. So Exhibit 3 has the ammunition. Exhibit 2 has that handgun?
Correct.
Okay. What kind of handgun is that?
A semi-automatic handgun?
Is it a 9mm?
I believe so, correct.
Did you make any notes about the type of handgun in your report?
Not that I recall.
At the time that this happened, was it loaded?
Yes.
All right. Currently, in frame right now, is the magazine inserted into the body of the gun?
Yes, it is.
Objection.
What's the objection?
Relevance to the gun being loaded. That's perfectly legal.
Response?
I'm not saying it's illegal, it's just a firearm that was
You're
loaded.
trying to sway the judgment here by making it seem more dangerous than it is. Anybody who carries a firearm usually carries it loaded.
I think that it's relevant as to the description of what the officer saw, so the objection's overruled.
Does there appear to be any tampering with exhibits 2 and 3 right there that you have?
No, sir.
I know with firearms, I don't know how the court would like to handle the admission of it, or if it would prefer that we simply acknowledge that it exists. That's up to the court.
You can just mark them just for reference.
I will mark, the more I think about it, I'm just going to admit it. So I move to admit exhibits 2 and 3.
Any objection?
No.
Exhibits 2 and 3 are admitted.
Give me just a second, officer, see if I have any other questions for you. All right. Did you let Officer Duran know that you found the firearm after this was done?
Yes, I did.
All right. No further questions, Your Honor.
All right. Any cross-examination of Officer Maldonado?
I did. Let me just do a quick rundown real quick to make sure that I'm not going to...
All right. Well, Mr. Reed's doing that on that approach and provide the court with states 1A and 1B.
Thank you.
Okay. What was your role during the traffic stop during the December 12th?
So what all did you notice that I didn't point out? And the reason Richard is representing himself is because in Arizona, you're not afforded an attorney if the state's not seeking jail time. And Richard can't afford one, so no lawyer. I'll be releasing part 3 of this within 24 hours. Part 3 will conclude Richard's trial, and you would be doing him a huge favor if you followed the link in the description and the pinned comment over to his channel and subscribed. Thanks for watching. By the way, I don't know if you've seen this or not, but it is the Direct D branded Smoker's Traveler's Kit. This is a glass blunt or a one-hitter with the Direct D logo on it, a hard case with the Direct D logo on it, and a Bic lighter with the Direct D logo on it. It's amazing. It's amazing. It's available on OutfitterFreedom.com. The link to that website will be in the pinned comment and the description of this video. Definitely go get yourself one of these. Every pothead needs a Direct D Smoker's Kit. Trust me. You're not cool unless you have one.